Hey guys, and welcome back to the channel. Today we've got 3 sovereign citizen cases to cover. The first comes from the mother of a sovereign citizen who wants absolutely nothing to do with her son after he assaulted a family member with a pair of scissors or shears. The second features the classic, not in commerce, free traveler routine. You know, the usual sovereign citizen logic for why the rules apparently don't apply to them. And third, we've got a sovereign citizen on the verge of losing his house because the state Treasury Department, unsurprisingly, will not accept his homemade discharge of debt as payment for property taxes he's owed since 2023. We're starting with the first case since it's the shortest. This one involves a young sovereign citizen who got arrested, was released, and promptly made life hell for his entire family. The mother, her husband, and the siblings eventually had to leave the house for a few days. And when they came back, they brought their uncle along to help remove him from the property. Things escalated quickly. He stabbed the uncle with some kind of sharp object and attacked the mother's husband, which landed him right back behind bars where he started. I trimmed the opening section since it was mostly background on his original arrest, but I kept the mother's victim statement in because it really speaks for itself. All right, let's get into it.
All right, Miss Gray, what would you like to tell me? I'm most interested in whether you wish to have contact with the defendant and if you have concerns for your safety.
Yes, I do. I also have other kids in the home. I have a 23-year-old daughter in the home. I have a 15-year-old son in the home. I have an 8-year-old daughter in the home. Mr. Gray is my oldest child. He drops in and drops out. Okay. I can't have someone come there terrorizing me and my kids in the home that I have built for the last 16 years. My husband and I have built for the last 16 years. Mr. Gray is on some mess trying to live like he's one of those sovereignty people. Those people that squabble all the time and just take over people things, because they don't want to get up and get it on their own.
All right, so it's fair to say you don't wish for him to return to that address.
I don't wish for him to return to the address. No.
Yes, ma'am.
I feel like it would be unsafe. It would be unsafe for me, my husband, and my other 3 kids.
All right. I do appreciate you coming to court making that statement. Defendant's going to receive $1,500 surety bond. He's to have no contact with Miss Gray or Mr. Robinson during the pendency of this case. He's to stay away from that location, have no alcohol, no drugs, no weapons. His case is going to state all purpose on March the 10th, and I am going to ask for the social worker visit for additional development of the matter. Best of luck to you, Mr. Gray. That concludes your case for today and to all parties concerned.
And that's a wrap on the first one. I've said it before and I'll say it again. If you want a one-way ticket out of every family gathering, holiday dinner, and living arrangement known to man, just become a flat earther or a sovereign citizen. Works every time. Now let's move on to our second hearing, where a sovereign citizen gets pulled over for a busted tail light and somehow manages to also get cited for having no insurance.
And so for you, Mr. Nope, is it still your intention to move forward with a contested hearing?
I'm sorry, sir. I'm having a very difficult time hearing you. Could you please speak a little louder?
Sure. I was just confirming it's still your intention to move forward with a contested hearing today.
Well, sir, I am being put in a contested hearing box, but if you've noticed all the documents I've sent to the court, I'm challenging much more than that, including I'm here by special appearance only. I'm not here by general appearance. I'm challenging jurisdiction. I'm challenging every aspect of this and violations of due process, violations of law, and the fact that I was never notified about this and that it was already turned into a committed without me ever receiving any notification. Have you had a chance to review all of my letters and requests for disclosure and discovery, my affidavits? I've put many documents into this, and I'm challenging all aspects. So I can't really even say it's just a contested hearing, other than that's the only box you gave me any possibility to sign on this thing. And by the way, this was only a warning I was given. I was never issued a citation. The citation is not a the warning is not a charging instrument. It's simply a warning. I've been stopped times before, and no citations were issued. And I've been stopped after and no citations were issued. This one suddenly miraculously turned into a citation long after the fact, and it was already termed committed, which is absolutely a violation of my due process. I would also challenge entirely the officer's report and the citation and many other aspects in regard to due process and law. And I can say much more if you will allow me.
All right. Well, Mr. Nope, give me a moment here. I do have all your documents here, and I'm looking at the docket notes for your case as well. So let me take a look at a couple of things here, sir. Okay.
I'm sorry, I couldn't hear that last part.
I said I've got your documents here in front of me, and I'm going to take a look at a few things here before we move forward. I'm going to get myself more up to speed, but I do have all your documents here, so give me a moment, please.
Okay, thank you.
All right, Mr. No, have you received any documentation from the prosecutor's office in response to your demand for discovery? Looks like that was filed on January 13th.
Well, no response was ever made to all my requests for disclosure and discovery or my affidavits. So I would assume they stand as fact in law. They were not rebutted or they were never answered. Then I did get from the office, not from the prosecutor himself, but from the office, from some woman claiming to write the affidavit, and sent a copy again of the officer's report, which I will contest every element of, and the citation again, as if that is all I'm entitled to in terms of discovery and disclosure, which I do not believe is proper. That is why I already put in my motion to dismiss for violations of due process. I have done this before. I have been conferring with legal professionals all the way through this, including a professor of law at a major law university. And everything I'm doing, it has a basis in law and is about my due process. I'm not in the category or status that it can be limited in the way that it seems to be trying to be limited. And I can read that off for you I have it written down if you would like, though it is in my affidavits and all my other requests. I'm not, I've been misidentified. That's in my affidavit. I'm not an incorporated person or a 14th Amendment citizen. I have been mistreated by this court very badly in the past, and my proof of my foundational instrument, a handwritten cursive note of real birth, not a birth certificate issued on bank paper, none of that. I introduced that as evidence in this court once before, and they took it from me and never returned it. So that evidence being taken from me and never returned has caused great problems. But I've done the affidavit that shows I'm not in the debtor category. I'm not a 14th Amendment citizen. I'm not an incorporated citizen. All of those, as well as the misidentification in all capital letters, which has real foundations in law. So I've asked for this to be dismissed in many ways, and I'm still asking for that. And I will contest many elements in the officer's report, citation, and the circumstances in which it occurred, which were very improper.
Do a little warning next time before you unleash a crayon-laden sovereign citizen word salad on the rest of us. Some people are eating. But to actually address your argument that you're somehow not a 14th Amendment citizen of the United States, even if that were true, and it isn't, it wouldn't matter. Even non-citizens are required by law to carry proof of insurance when operating a vehicle in Washington state, as governed by RCW 46.30.020, which is pretty clear that no person may operate a motor vehicle on Washington roadways without insurance. So even in the universe where you're right, you're still wrong.
All right, so what we're going to do, Mr. Nope, I'm going to put you under oath. All right, I'm going to ask you some questions. about what happened, and I'll try to also kind of walk through, how we got here. So please raise your right hand. All right. You swear or affirm the testimony you're about to provide is the truth, the whole truth?
As best I can remember, yes.
All right. So first of all, to address the issue with the earlier finding of committed, it looks like that was found committed due to a failure to respond, which does happen after folks don't respond to a traffic ticket. Part of that notice of infraction that you get does outline ways to respond and some deadlines, and we don't hear a response that becomes a found committed. Now you're here, which means if folks, even after it's found committed, if they engage with the court and set a hearing, then they are able to come back and contest their tickets here. So we are here at a contested hearing despite that earlier finding of committed. All right. Now it sounds to me like based on what you've submitted and what you're saying today, you've got two issues here. It's like the stop and then the issue with driving without insurance.
Yes,
right,
this is not a moving violation. This is a paperwork's warning.
Well, I'll let you. I've read the police officer's report as well. I know you've already said made some arguments here, but now you're under oath, so I'll go ahead and let you explain your position with respect to what's in the officer's report. That is what we're focusing on here. Is just that October 11th traffic stop and the allegation of driving without insurance. So go ahead.
Okay, so I want to make sure I understand. You're telling me I'm only have the opportunity now to challenge the officer's report right now? Is that what you're asking for?
Well, no, I'm saying that's the officer's report is alleging you were driving without insurance. And if you want me to find that not committed, I would suggest that that's what you focus your arguments on.
Okay. If you look at the officer's report, it is false where he states he was in the very beginning. The officer was down a side street perpendicular to the road coming down out of Rainier. Perpendicular, hiding in the dark on a side street at approximately 12 midnight. I saw the officer car from way ahead. It's a 25-mile-an-hour speed zone at the bottom of a hill, but I was not speeding, nor did he stop me for speeding. Hang on. The officer could not see my brake lights one brake light that he's claiming was out from that position. Also, I might add, there were two officers, and that's omitted completely from this officer's report. There were two officers, and one tried to give me legal advice. Now, I was not speeding. I saw him. I went down the hill. He was already pulling out after me before he could ever see any brake lights. Then, as I went forward to the stop there, the stop sign in the town of Rainier, that would be the only place he could have seen that. He is misstating completely. First of all, he was not driving, as he said. He was parked down a side road.
I'm going to just butt in here a little bit. So you're not cited for driving without a brake light. I understand that was the reason for the stop. The citation here is for driving without having your insurance.
Right, I'm getting to that.
Right. I would suggest that you get to that a little bit quicker.
Well, these are the circumstances that prove that he's not telling the truth, in my point of view.
Your entire legal worldview is delusional, and frankly, so are whatever legal professionals and professors fed you this nonsense. But please, go ahead. Keep telling us how uniquely special you are and how the laws that apply to every other human being somehow skip right over you.
So, he's not even saying properly where it occurred, because I was stopped out on the highway. He then followed me after I made the turn on Highway 507 toward Yelm, and followed me for a great distance before he made the stop. So his report is false, where he's even saying he stopped me. It was not at the intersection of Binghamton and Idaho streets. That was where he was hiding, down low, where it started from. But it's not where he stopped me at all. So that is false. The next thing is he is not telling the truth about the discussion that went down there. Okay. And I put him on notice if any of my rights were violated or my due process was violated, that I would take the matter further into court. And that is what I'm doing. So many elements of this are improper. So I asked for this officer's report to be a cause for dismissal, as well as all the other things I've motioned.
Well, Mr. Nope, what you haven't said is you haven't denied that you were driving without insurance. Is that what you're arguing?
Well, the point is are you making me an offer as if I have insurance now, or are you asking me a question about then?
On October 11th, 2025.
I think I have the right to not answer that question under the Fifth Amendment because of all the other issues I've outlined that are improper in this case.
Well, Mr. Nope, you don't have to answer, but the officer said that when he pulled you over, indicated that you didn't have insurance, and driving without insurance is an infraction under state law. And so I do find that infraction has been committed.
Wait a minute. That is not what he said. He said I didn't show him proof in that moment. He then demanded that I email the proof to him, which is not proper or due process at all. It was not that I did not have it or show it. He simply claimed that I did not show him proof at that moment.
Are you saying you showed him proof?
What's that?
Are you telling me that you showed him proof of your insurance?
I handed him a bunch of stuff that I wanted to get out of there because I felt the situation was very dangerous. I don't recall what I actually handed him, but I also gave him the discussion that I'm not operating in commerce and I do not believe I am required to carry commercial insurance as that RCW is suggesting, or that it can be proven to apply to me.
It's genuinely rare to hear someone come right out and say, verbatim, that laws don't apply to them. Most of them dance around it. But this guy just went ahead and said it out loud. Bold move. Anyway, it's time for the judge to step in and explain how reality works.
All right, well, Mr. Nope, I am finding that the infraction committed. The RCW does say failure to provide proof of motor vehicle insurance is a traffic infraction. And you are required to carry motor vehicle insurance while driving on the public road. So I do find that committed. All right, you'll have 60 days to pay that, the ticket amount. And I understand that's not the outcome you're looking for here today, but that's the ruling of the court.
Then, well, I would like to say something more.
Well, Mr. There is an appeal process. All right, we got a lot of folks on the calendar today, and we are going to move on.
Right? I need to ask about appeal. I need to appeal this then. Right. So well, I need to get the form for informa pauperis to be able to appeal this because I cannot pay the fine or the filing fees to appeal this. So I will be appealing this, and I need to know what I have to do.
What you got to do is you contact the Thurston County Superior Court Clerk's Office, and they can get you all the information you need for appealing a traffic citation out of district court. That's where the appeal goes.
And how much time do I have to do that?
They'll be able to tell you that process is over in Superior Court. So talk to them and they'll let you know.
All right. So that's the end of hearing number 2. It must suck to be a sovereign citizen and know that everyone else in the world isn't as delusional as you are. Now it's time for case number 3.
Mr. Powell, would you unmute yourself, turn on your camera, and state your name, please?
Powell, Michael Elliott, authorized agent for Michael Elliott Powell.
Ms. Soroka, what property?
Yes, Your Honor, Mayada Soroka with Wayne County Corporation Counsel appearing on behalf of the treasurer and Mr. Powell's objection to foreclosure of the residential property located at Courtlands in Detroit with parcel ID number 21020155 is based on his statement that the taxes have been paid and exempt from levy. However, currently there is a property tax delinquency in the amount of $1,931.34, which consists of tax year 2023. And this is the date and time designated for Mr. Powell to be provided with an opportunity to address the court.
Mr. Powell?
Okay, let me open up the email because she didn't state the entire objection. I've been waiting for about 3 hours, so I didn't know you guys gave me improper notice. I had to call in and get the meeting ID, and I'm currently doing something. So I'm about to pull open this email that I sent them so we could get to the bottom of it. That wasn't the entire objection. The entire objection is, okay, taxes been paid, and what she said, property or security so deposited is exempt from levy. I tendered twice the amount in December. So in December, it was due $1,881.64. I tendered a total of $3,763.28 in security, exclusive of interest, costs, and attorney fees on the liens entered against me on the official tax of Eric R. Sabri. These payments equal to the amounts which I was liable for under the official tax. I presented a verified claim for $1,881.64 to the treasurer. The claim contained the statement of facts stated right now and demanded payment of the $1,881.64 in conformity with the official tax of the treasurer. More than 45 days has elapsed since that presentation and demand of claim, during which time Eric R. Sabri has failed to allow or reject the claim. So he's in default for not returning my security to the delinquent tax revolving fund. Everything has been provided to them, and
Your Honor, the fact remains that there is a property tax delinquency for 2023 in the amount of $1,931.34. If this amount is not paid in full, or a payment agreement has not been entered into by March 31st of 2026, the property will be foreclosed.
Okay.
We would recommend that you speak to one of the treasurer's representatives who is here today to enter into a payment agreement or to be provided with payment options.
That's not a response to what I said. So I already tendered payment. It's in your possession, and I have a receipt from Comerica Bank that you deposited my payment in Comerica Bank. So you keep saying that your record is incorrect, and I know that. I just said I filed a claim.
Excuse me, sir. Did you attach a copy of the proof that you made the payment?
No, because nobody asked me to.
Well, if
the opposite party has not requested any type of proof. So affidavit, unchallenged affidavit is proof. She hasn't challenged any part of what I just said.
Okay,
all she did was, go ahead.
At this time, if you're saying that you made the payment, all we need to do to confirm it so that we can get this off the tax roll is verification. Mr.
Right. And I would like her to go get what's in the Comerica Bank and show the court what they put in Comerica Bank, because at this point they lost it.
No. If you made a deposit, that you just have to have your proof. But anyway, Mr.
I sent proof. Go ahead.
Excuse me?
I said I sent proof.
Just hold on, sir.
Your Honor, any payments that would have been made by Mr. Powell would have been applied to any tax delinquency. Usually it is applied to prior tax delinquency years, and then what is remaining is this $1,931.34 for tax year 2023.
Is there...
Right. And I've spoken with somebody at the Treasury Department multiple times and provided proof. Okay, I sent a claim on the amount Hold on a second. I sent a claim on the amount I paid. It's been more than 45 days. It has not been rejected. I have not been contacted about, and that's accord and satisfaction.
Your Honor, it seems to me that Mr. Powell is assuming that there is some sort of breach of contract here on the part of the treasurer. But the Wayne County treasurer, in performing his duties, is not classified as a debt collector in the state of Michigan, and is therefore statutorily exempt from the definition of the debt collector under the Fair Debt.
I didn't say the word debt
Hold on.
collector.
Okay, Mr. Powell, you cannot interrupt, please. Thank you. Go ahead.
But this is not a contract or an accord or satisfaction or any sort of, situation that Mr. Powell is claiming. I think Attorney Don Lee Cotton has looked up the tax payments and would like to address the court.
Ms. Cotton?
Yes, Your Honor. Mr. Powell has been in contact with our office, and we've spoken to him multiple times as to what he sent into Comerica Bank. And I just forwarded to Attorney Soroki what indeed was submitted was just the tax bill where he stamped it, just stating that it was tender.
That's not a thing. You cannot discharge a legally owed debt by mailing someone a stamped letter that says the debt is discharged. If that worked, every person in America would buy a beachfront mansion and pay it off with a sticky note and a rubber stamp. If you actually want to keep your house, whatever you're sending in that envelope needs to be real, accepted legal tender, not an arts and crafts project.
Okay, but Mr. If you didn't pay any money,
that's not what happened.
Money order.
That nobody asked me what happened. So let me go ahead and clarify. I have the right to send a bond to the treasurer secured by public obligations. I sent the bond to the treasurer secured by the public obligations of the court of the county. I have the law to tell you on the record right now.
No, you don't need to. You don't need to tell me the law.
Okay,
hold on,
they said,
Mr. Powell. The only thing you need to do, you need to pay the 1,000.
I did.
Hold on, sir. Mr. Powell. I told you stop interrupting, please.
Okay, y'all interrupted me.
You know what, Mr. Powell, we're going to put you on mute because you don't know how to let someone else speak. Everyone else is letting you speak. Anyway, if he has not paid the funds, not sending a document, putting whatever he wanted to on it, if the funds have not been paid in U.S. currency or U.S. currency equivalent, the debt has not been satisfied. So at this point in time, Mr. Powell, you owe $1,000, and correct me if I'm wrong, somebody, $1,931.34. Did I say that correctly?
Yes, Your Honor.
You owe that in tender.
May I correct you?
U.S. No, you cannot.
You said correct you if you're wrong. You just said somebody correct me if I'm wrong.
I was talking to the
You
county.
said somebody. You didn't say county.
Anyway, as I indicated, if it has not been tendered in U.S. currency, not putting a statement on it, that is not sufficient. You must pay the $1,931.34 by March 31st, or else there will be a foreclosure on this property.
I understand what you just said. Now, you just said before that equivalent U.S. currency.
No, I didn't. No. I'm done.
It's been recorded.
Okay, fine.
I know it has. You literally said currency.
Okay, but
you said currency equivalent, ma'am.
If you haven't paid,
I did.
I'm done, Mr.
I have proof.
I'm done.
Okay,
I'm done. And as I indicated, if it's not satisfactory funds, if the funds have not been paid, then your property will be foreclosed on March the 31st. You need to make sure you pay that $1,931.34 by March 31st.
I'm going to tell you again.
You need to pay it by March 31st, or the property will be foreclosed on. No notice, no anything. If it doesn't satisfy, you don't pay those in U.S. currency funds, and equivalent means a credit card, a checking account. That's all that's acceptable. If you do not do that, your property will be foreclosed upon March 31st.
I understand everything you're saying.
Okay, that's all.
Now, may I be? Okay, why am I here if I can't be fully heard?
Because you're not.
I have the First Amendment right to be fully heard.
You have 2 minutes, sir. 2 minutes.
Okay, thank you for allowing my First Amendment right to be fully heard.
2 minutes.
Can I reset it since you interrupted me? So, I deposited cash equivalent, according to United States law, which is the governing law of all United States currency. Title 31, United States Code, Section 9303, is the code that you're quoting without quoting it. So it says, I may use a government obligation for security instead of a surety bond, which is the same as using cash, check, or money order. I sent a bond, a claim to the treasurer with or secured by the public obligations of the treasurer, which I have the legal right to do, negotiable by delivery, which was deposited into Comerica Bank. I did not send it to Comerica Bank. I sent it to the P.O. box of the treasurer. However, they sent me a receipt signed by Comerica. So if they sent me a receipt by Comerica, that means the treasurer received my documentation, my documentary evidence, and deposited himself in Comerica Bank. I didn't send anything to Comerica Bank directly. I'm telling you, I have a receipt from Comerica Bank, signed Comerica. However, I sent it to the P.O. box of the treasurer. So the treasurer obviously sent it himself to Comerica Bank. Now, I haven't been rejected. Comerica Bank hasn't called me, has not sent back anything to me, has not rejected anything I sent whatsoever. However, they have accepted for more than 45 days now. Now, the law says clearly, using a government obligation for security instead of a surety bond is the same as using cash, check, or security. That's what a cash equivalent is. That's what it says in the United States law. Title 31, U.S. Code, Section 9303, if anybody would like to look that up.
Okay,
Also,
your time is up, sir.
Hey, okay, listen, I will file a request for your oath of office and your bond. The other law is Michigan compiled law. The Michigan compiled law 221.87 at sequence, which is the accounts and settlement thereof.
First of all, MCL 221.87 doesn't exist. What you were fumbling toward was MCL 211.87, which covers how state and county treasurers handle tax accounts and interest on delinquent payments. And it does not say what you think it says. You also cited 31 USC 9303, which has nothing to do with your situation. That code applies to people who are required to post a surety bond, like a contractor on a federal building project, and allows them to substitute an eligible financial obligation instead of going through a private insurer. It has absolutely zero relevance to your property tax bill. Nobody here is falling for the sovereign citizen fraud routine, and if that lien isn't paid off within the month, you will lose your house to foreclosure. Simple as that.
If they actually looked into the law, they would see that I deposited, which was supposed to be put into the delinquent tax revolving fund. And I could quote I could read exactly what the law says for the record.
No, you don't have to, Mr. I've given you more time than I indicated. So at this point,
Then you indicate I don't have the right to be fully heard.
No, you don't. I gave you 2
I'm
minutes,
speaking
sir.
relevant. You gave me 2 minutes.
Sir.
So this is a privilege hearing.
No, thank you very much. Well, that concludes this hearing, Mr. Powell.
Okay, let the record reflect.
That concludes this hearing. Thank you very much, sir.
And that's a wrap, folks. All three of today's sovereign citizens have managed to paddle themselves into the deep end without a life jacket. And honestly, at this point, that's just a Tuesday. If you enjoyed the video, hit that like button. If it wasn't your thing, the dislike button exists too. Drop a comment below letting me know what you think, and make sure you're subscribed with notifications on so you never miss a new upload. I'll catch you in the next one.